Hey guys, welcome back to A Little Less Lisa. This channel is all about my health, wellness, fitness, weight loss maintenance journey, but today we're going to take a little bit of a divergent road here, and we're going to talk about the lawsuit between the OFA and the FDA and now Eli Lilly, which has inserted itself into the proceedings. Now, I am an attorney by trade. I don't practice in this area of the law, just an FYI, I guess, a little disclaimer here. And I haven't weighed in on any, that's sort of a pun, I guess, any of the proceedings before, because honestly, I feel like a lot of people have covered it very well within sort of the GLP-1 arena here and content creators. But given kind of what's going on, I wanted to, I guess, talk a little bit about the most recent order that the court issued on Monday, as well as talk about the fact that the hearing that was set to happen on Friday has actually been postponed until Monday now because of potential severe weather in Texas. But anyway, like I said, I just thought maybe I would weigh in a little bit here on my thoughts about the case, about the merits of the case, and especially about the order that happened on Monday and what I think that means for this whole lawsuit. So let's go back a little bit. I have the actual complaint, aka the lawsuit, that was filed in the Northern District of Texas, the Fort Worth Division, in front of Judge Mark Pittman. He is a United States District Judge, I guess somewhat well known to be potentially favorable in these kind of cases. He has been known to rule against Big Pharma and, rule against sort of overstepping of governmental agencies, things like that. So there are, I think maybe it was like 6 causes of action or so that we will go over here. I do have some highlights here, so I'll try to go over those. So basically, the OFA, also known as the Outsourcing Facilities Association, which basically is an association made up of outsourcing facilities who are doing the majority of this sort of bulk compounding of tirzepatide and semaglutide, have, like I said, filed this lawsuit against the FDA, basically claiming that meaning the FDA, removed tirzepatide from the FDA shortage list in sort of an arbitrary and capricious manner. And let's dive into that a little bit. So it says on October 2nd, the FDA changed all that with a post to its website abruptly depriving patients of a much needed treatment and artificially raising drug prices. Ignoring evidence that the shortage persists, FDA removed tirzepatide from the shortage list without notice, without soliciting input from affected parties and the public, and without meaningful rationale. And you'll see that as a very common theme through this whole lawsuit that talks about the fact that the FDA just did not follow proper procedure, that it made its decision based on pretty much only taking Eli Lilly's perspective on it, that it didn't get, input from the public on it through hearings, that it ignored data and information that it had from the public and other interested parties, and that it just arbitrarily took it off of the shortage list. The Administrative Procedure Act, also known as the APA, secures the foundational principle that, quote, the government should turn square corners in dealing with the people, just as regulated parties must turn square corners when they deal with the government. This is a quote from a case that is cited of Department of Homeland Security versus the Regents of the University of California. Under the APA, FDA's decision to remove a drug from the shortage list is clearly a substantive rule, which means a rule that establishes legal rights and duties. Because of the profound impact of substantive rules, the APA demands that agencies undergo notice and comment rulemaking before promulgating them. An agency must propose and give notice of its action in the Federal Register, solicit comments from interested parties, and in its final decision, explain its rationale and address the meaningful comments it receives in a reasoned and transparent decision. So basically what it's saying is that the FDA is governed by this APA and that their decision qualifies as a substantive rule, which then requires the FDA to go through this formal process of giving notice through the Federal Register, and then to get comments and opinions from other people, and then to explain, an additional point, its rationale and address, the comments and things that it received so that people can fully understand how they addressed those comments and why their decision makes sense. Hopefully that all makes sense. Then it goes through the different parties, it explains that, it goes through jurisdiction and venue. These are all part of standard civil procedure rules that when you're filing a complaint, you have to address these things in a complaint to say that, the jurisdiction is proper, that venue is proper, because those are things that you could potentially challenge as a defendant, for example, because obviously the plaintiff is the one that brings the action here. So here's some factual and legal background. So this first piece is Congress identifies compounding as an effective, efficient, and appropriate means of meeting patient need and market demand during drug shortages. And it goes on to explain the rules governing 503B and 503A pharmacies and why they were promulgated in the first place and, the rationale behind them, etc. And basically the bottom line after going through sort of this whole explanation of 503A and 503B pharmacies is that the scheme reflects a decidedly patient-focused orientation of compounding restrictions under the FDCA and specifically Congress's considered judgment that compounding by pharmacies and outsourcing facilities is an efficient and effective means of ensuring patient needs are satisfied when an FDA-approved drug is in shortage. So basically, we've sort of, like I said, laid the foundation of why Congress enacted these different ways to compound and manufacture medications, and that it is patient-focused, which I think is going to be important here. Next point, FDA abruptly declares victory over a drug shortage that manifestly persists without notice, opportunity to comment, or a reasoned decision. So again, this is going back to the APA that states, if they're going to do this, they need to go through the proper process. So again, going back to this whole notice thing, while the FDCA requires FDA to consider information provided by a drug manufacturer in addressing a shortage, it does not limit the FDA to that information. To the contrary, an agency required by law to engage in informed decision-making must consider all relevant information at its disposal, not only information supplied by a self-interested market participant whose production failings caused the shortage in the first instance and which has an overriding incentive to make a one-sided presentation to the agency. They're basically saying, look, the only perspective you got was from Eli Lilly, and clearly that's a biased perspective, right? It says further down in its notice, FDA offered a generic assertion that it typically, quote, considers a variety of factors, including the company's ability to meet current and historical demand, the amount in a manufacturer's stock, affected market share, ability of alternate manufacturers to cover the demand, and confirmed market stabilization. But the notice says nothing of FDA's findings, even at a high level, under any of those criteria or any others concerning Tirzepatide. As noted, the sole case-specific assertion in the notice references FDA's singular reliance on communication with Tirzepatide's manufacturer. So again, what they're pointing to here is, look, all you did was, pick up the phone and call Eli Lilly and say, hey dudes, do you have enough medication to cover? And that's apparently, again, that is what the OFA is alleging here, is what happened. And they're basing that based on the FDA's own notice and what they said in their notice. FDA's express recognition that supply disruptions will continue to thwart patient needs and leave market demand unsatisfied, and that patients will not always be able to immediately fill their prescription, is a confirmation on the face of FDA's notice that its determination was arbitrary, capricious, and unsupported by anything but the self-interested assertions of a market participant. The first cause of action is agency rulemaking without requisite notice, comment, and explained decision. And then just a few salient points under here. The APA establishes a notice and comment rulemaking requirement that applies to all agency rulemaking with limited exception that do not apply here. FDA's delisting decision is a legislative rule that is subject to the notice and comment requirement because it has the force and effect of law. And after that, they're quoting an actual case that obviously must have, has similar facts. So when you're quoting a case, you generally are looking for cases that have a similar fact pattern, etc., and that support, obviously, your case. FDA's delisting decision is not eligible for the exemption from notice and comment requirements applicable to interpretive rules, general statements of policy, or rules of agency organization, procedure, or practice. FDA's delisting is not interpreting a legal provision, making a general policy statement, or governing the agency's internal process. Rather, a delisting decision declares previously lawful activity regarded by Congress as beneficial to be unlawful. And so what they're basically saying, because they probably assume that the FDA is going to stand by the fact that they think that what they were doing in this particular case is interpreting rules, general statements of policy, or rules of agency organization, procedure, or practice, and that if it falls under that, they don't have to have this notice and comment and whole procedure, right? They can just do what they do. What the OFA is alleging or, asserting here is that no, taking it off of the shortage list becomes an actual act of law, right? Or it deems an activity that was lawful now to be unlawful, and that as such, it falls under the requirement of needing to have notice and public comment, etc. Sorry that the heat just kicked on. You will see that some of these causes of action sort of become, I don't want to say duplicative, but they kind of start reiterating some of the same facts. But you know what? As lawyers, it's just what we do. Second cause of action, lack of reasoned decision-making by omission of rationale sufficient to explain final agency action. The APA obligates agencies to engage in reasoned decision-making and directs their actions to be set aside if arbitrary and capricious. This includes requirements that agencies consider relevant factors and provide an explanation for their final actions. This standard obligates an agency to, quote, examine the relevant data and articulate a satisfactory explanation for its action, including a rational connection between facts found and the choice made. So basically what they're saying is, look, you didn't give us any explanation. You didn't take into account anything other than Eli Lilly saying, yeah, we got it. So it's arbitrary and capricious. FDA's sole basis for final action removing Tirzepatide from the shortage list was its representation that it, quote, confirmed with the drug's manufacturer that their stated product availability and manufacturing capacity can meet the present and projected national demand. FDA's notice of decision, the sole basis on which its decision could be upheld, says nothing of the manufacturer's ability to meet current and historical demand, parenthesis, apart from the manufacturer's own representations, the manufacturer's stock, affected market share, ability of alternate manufacturers to cover the demand, and confirmed market stabilization, which are all things that are indicated as by the FDA as what it, should take into account. FDA's notice of decision also says nothing of other factors like patient needs, evidence of market scarcity, and regional supply and demand. FDA's notice of decision further does not address evidence FDA received from market participants evidencing continued inability of supply cannot keep pace with demand. So basically, the statement here is that their decision took nothing into account. We all have been going and reporting shortages on the FDA's website. There was no consideration of the fact that there are millions of people taking compounded medicine, and that therefore once those people are no longer able to get that medicine, that if they have to go and switch to name brand medication, whether the manufacturer will be able to support those additional requirements, right? FDA's notice of decision does not address the fact that large segments of the market and much existing patient need for Tirzepatide were, before October 2nd, being served by compounded versions of the drugs. So, exactly what I just said, right? There was nothing to address the fact that you have all these people now who aren't going to be able to get compounded Tirzepatide, which, many of which will move or have to move to the name brand drug, pay a lot more money, and those people were not factored in to whether or not Eli Lilly can actually maintain its supply out of shortage. And then finally, they do note that the FDA's notice of decision does not address the likely impact of the massive port worker strike commenced the day before the decision. So there was a note earlier in the case when they were setting out the facts that the port workers did go on to strike, and that, that could have an impact because the API does come from abroad in most cases. So it does have to come through ports, and if there are slowdowns in the ports, it means that therefore the API can't get to Eli Lilly, which means, we'll have some more shortages. FDA's final decision removing Tirzepatide from the shortage list is therefore arbitrary and capricious under the APA and must be set aside. Third cause of action, lack of reasoned decision-making by facially contradictory findings that refute or undermine the basis of final agency action. So this is all about the fact that basically there are factual things out there that state that their decision makes no sense and that undermine their decision, right? The APA obligates agencies to engage in reasoned decision-making and directs that their actions be set aside if arbitrary and capricious. This principle forbids agencies to predicate their actions on determinations that are facially incoherent or inconsistent. And what they're now discussing here is the fact that in its own decision and in its own notes in that decision, it talks about the fact that patients may still have an issue finding their medicine. So it's like you're talking out of both sides of your head, right? On the one hand, you're saying, oh no, yeah, the shortage is over. Oh, but wait, you still might have some problems finding your medicine. A little odd. At a minimum, the notice is contradictory and insufficient to support the final action. The notice makes no attempt to square the finding that the shortage has ended with the statements that supply disruptions are expected to continue. This incompatibility renders the notice arbitrary and capricious on its face. Fourth cause of action, arbitrary and capricious determination that Tirzepatide shortage has ended. It basically just kind of restates a lot of what we've already talked about, that it's arbitrary and capricious and that therefore it should be set aside. The fifth cause of action is unlawful interpretation and application of drug shortage statute. The FDCA requires FDA to, quote, maintain an up-to-date list of drugs that are determined by the Secretary to be in shortage in the United States. This leaves FDA no discretion to remove a drug from the shortage list in circumstances where, quote, demand or projected demand for the drug within the United States exceeds the supply of the drug, end quote. But FDA's own findings represent the projected demand for Tirzepatide will exceed supply of the drug. FDA found that, quote, supply disruptions will persist, quote, due to factors like ordering practices and incentives, cold chain logistical considerations, and retailer capacity constraints. The statute leaves FDA no avenue to remove a drug from the list in the face of its own findings of this effect. FDA's final decision removing Tirzepatide from the shortage list is therefore contrary to law under the APA and must be set aside. Sixth, and I believe final cause of action, unlawful failure to publish decision in the Federal Register. So this all goes back to the requirement of the APA to publish in the Federal Register substantive rules of general applicability adopted and as authorized by law. And as I mentioned before, they are maintaining that the FDA's decision to take it off the shortage list effectually becomes an interpretation of the law. So it says FDA's decision to remove Tirzepatide from the shortage list is a legislative rule. It affects the individual rights of numerous market participants in a generally applicable manner. FDA did not publish its decision in the Federal Register. Their decision to remove Tirzepatide from the shortage list is therefore contrary to law under the APA and must be set aside. So then it goes into what's called the prayer for relief. And it's basically then saying to the judge, okay, so here were all the facts. Here's all of the different things that we think the FDA did wrong in this case. And now, judge, this is what we want you to do. Okay, that's what the prayer for relief is. So they want the judge to declare that FDA's final action removing Tirzepatide from the drug shortage list is contrary to law under the APA, which subjects the action to notice and comment rulemaking process. He wants him to declare the FDA's final action removing Tirzepatide from the drug shortage list is arbitrary and capricious and in violation of the APA. They're asking him to vacate or set aside the FDA's final action removing Tirzepatide from the drug shortage list on the grounds stated above. They are asking him to permanently and temporarily enjoin. It's interesting. How do you permanently and temporarily? Are those two conflicting statements? But anyway, enjoin FDA from taking action against plaintiffs for engaging in compounding of Tirzepatide that is lawful in circumstances where Tirzepatide is named on the drug shortage list. They also want him to issue a temporary restraining order lasting 14 days, enjoining FDA from taking action against plaintiffs for engaging in compounding of Tirzepatide that is lawful in circumstances where Tirzepatide is named on the drug shortage list during the time period when this court adjudicates plaintiffs' forthcoming motion for a preliminary injunction. And finally, awards plaintiffs' fees and grants any other relief as the court deems appropriate. So basically, it is anticipating filing a motion for a preliminary injunction, and so they're asking for a temporary restraining order in the meantime while they get that motion for preliminary injunction filed with the court, okay? So that was the original court filing. Now, as we know, shortly after that was filed, the FDA basically said, okay, hey, wait, time out, instead of going to court and doing all this stuff, let us go back and look, okay? So let us go back and make sure we've had all the information and all that kind of stuff. And then they were supposed to report back at, I think it was like December 2nd or December 4th or something like that. And they basically came back and said, we're not quite ready yet, so give us a little more time. And then if I remember correctly, I think it was on like December 19th, they came back and stood by their original decision, right? They stood by their decision to keep Tirzepatide off of the shortage list. To which now then basically the ball got punted back over to the plaintiffs in this case, or the OFA, to decide, okay, what do you want to do? And basically, if you go through some of the court filings and things like that, the judge had requested that, I think it was by January 2nd, that the parties, determine how they were going to move forward. And obviously that decision was made to move forward. And then in the meantime, Eli Lilly filed a motion to become an intervener into the case, which basically means, look, I have an interest in this case of how this case is decided. So I want to insert myself into the case. On Monday, this was an order that was given by the judge, and it has two sort of main functions. Now, there was supposed to be a hearing on January 10th that was going to, one, determine whether or not Eli Lilly should be able to intervene, and two, my understanding is to discuss the discovery or the information that the FDA submitted with its report of why they were going to maintain Tirzepatide off of the shortage list. And as a part of that, some of that information was redacted. And so that is going to be what the court addresses in the second part of the order. So let's talk about the order. All right, so I'll pop the order up here. It's very brief and we'll go over it. Before the court is Eli Lilly and company has motioned to intervene. Plaintiffs have filed a notice that they withdraw their opposition to the intervention. The court, finding that good cause exists for Eli Lilly's intervention in this case under Federal Rule of Civil Procedure 24, hereby grants Eli Lilly's motion to intervene. Okay, so as I said, Eli Lilly filed a motion to intervene. Originally, the plaintiffs opposed that, and then they decided to file a notice that they were withdrawing their opposition to that. The court is recognizing that withdrawal of their opposition and noting that under the rules of civil procedure, it is indeed appropriate to allow Eli Lilly to intervene in this case. So that concept, that whole part is now been resolved, right? Okay. Eli Lilly said, hey, we want to play in this sandbox with you. The judge said, yes, under the rules, you're allowed to play in this sandbox. We're all good. Okay. And then it goes on to say, while this order resolves half of the matters set for hearing on January 10th, the court finds it appropriate to continue with the hearing as scheduled. The court finds it prudent to do so for two reasons. Okay. And this is where I personally think it gets interesting and why I have the particular opinion that I do about how I think the judge is leaning in this case. First, having reviewed the submissions in this matter, okay, so the submissions, and specifically he's talking about the submissions made by the FDA, the court anticipates that the parties may have a dispute over the FDA's production of confidential information, which serves as the initiating action for the proposed briefing schedule. Okay, let's pause here for a second. Basically, what the judge is saying is he thinks that the OFA is going to take exception to the fact that the FDA redacted certain things that may be helpful to their case, right? In other words, let's say some of that information was, Eli Lilly's stock level, etc. And let's say they, I'm totally making up numbers here, right? Okay. Let's say they say we have enough stock in inventory right now to cover 1,000 people, right? Well, knowing that there are, let's say, 5,000 people on compounded tirzepatide. I'm, again, making these numbers up, people, that we know that these numbers are not correct. I'm just making numbers up for example purposes, okay? And let's say that only 20% of the people that are on compounded tirzepatide are able to, can afford to, whatever the case is, move to name brand medication if compounded tirzepatide goes away, right? Let's say the other 80% can't afford it, because honestly, that really would probably be the only reason that you wouldn't move to a name brand medication, right? And so 80% is not going to move, but the other 20%, so another 1,000 people, want to move. If what Eli Lilly said is we have enough of supply to supply 1,000 people, but yet we know that at least 1,000 other people are going to want to use name brand medication, by its own admission, Eli Lilly cannot maintain the supply that it needs, right? And therefore, it would put them into shortage, and it would make the FDA's decision to take them off the shortage list erroneous, okay? So my thought is that there is information there that the judge is saying, look, the plaintiff is going to want to know this information, and therefore we need to talk about that. And so that's one of the things we're going to talk about in this hearing. And this is why I think I have the opinion of why then he goes on to talk about the next point. Second, the court believes that consolidation is appropriate and would like to convert the plaintiff's impending motion for preliminary injunction into a motion for summary judgment under the Federal Rules of Civil Procedure 65. Then it goes on to say, summary judgment serves as the mechanism for deciding as a matter of law whether the agency action is ... consistent with the APA. So this is where my brain is going with this, okay? I think personally that this is a positive thing for the OFA, okay? If the judge didn't think that there was an issue, or that there was not going to be a discussion about the information that the FDA provided to support its decision, that the judge wouldn't be talking about summary judgment, okay? My thought is that he knows what information is there, and that therefore it doesn't matter that the OFA may want that information, because he knows that the information that's there supports the fact that it shouldn't be taken off the shortage list. So my thought personally, now, does this mean that this is all going to go away and that Eli Lilly is just going to, slink back into its turtle shell and hide its head and never come back? No, okay? Please do not misunderstand me. I do not think that this is the end. Even if, like I said, even if my instinct is that Judge Pittman would, on a motion for summary judgment, rule in favor of the plaintiffs in this case, this is not the end of the road, okay? Eli Lilly has Kirkland Ellis in their court, okay? This is like the behemoth of law firms in the United States, okay? It is not going to take this lying down. It will still go ahead and sue and threaten with cease and desist letters, which it's, already doing again. It's been sending them to telehealth companies. Anyway, it's not going to be the end of the road, okay? This is merely going to provide a little tiny bump, but anyway, we'll see what happens. But my opinion is, based on the way that, like I said, that this is worded, is that the judge thinks that there is information to be disclosed, and that as a result of that, in other words, if there is information that they think would be beneficial for the plaintiffs to know, the court is not going to take away that right from the plaintiffs, right? Because in general, a motion for summary judgment happens after discovery has happened, right? And so after discovery and each side has an opportunity to see all of the information from the other side, the court feels like it has enough evidence and enough information in front of it to be able to make a decision as a basis of law where you don't have to have a trial, okay? So the fact that the judge first says the court anticipates that the parties may have a dispute over the FDA's production of confidential information, to me indicates, like I said, that the judge knows that the parties are going to have a discussion about this. And the plaintiffs have a right to argue that, the defendant in this case, the FDA, did not basically fulfill their obligation in discovery, right? That they did not put forth the type of information that's required here. So I personally, like I said, I think that, to me, this is kind of good news as it relates. I could be completely wrong about this, guys, okay? I'm just giving you my own opinion based on reading this and just kind of like stepping through, the motions here. Now, the other thing I want to talk about is that, people have been saying, okay, well, we're going to know on Friday, and because it said, accordingly, each party should come prepared to discuss any issues it may have with the proposed briefing schedule. Additionally, the parties should come prepared to inform the undersigned whether they object to the court converting the motion for preliminary injunction to a motion for summary judgment. So it's not going to make a decision on Friday, which is now, as I said, Monday, right? Because of supposedly an impending snowstorm or severe weather that's coming to Texas. And if you don't know, if they see one flake of snow in Texas, like the whole world shuts down. So they're just going to come, they're going to present any arguments, they're going to come prepared to say, yeah, that's great. We think going into summary judgment works for us, judge. And then the judge will go, take however long the judge is going to take. This judge has been pretty quick on things, so I wouldn't anticipate that a ruling would take very long after Monday's hearing, but it's not going to come on Monday, okay? Right? The judge has to then go back and give some consideration and look at the facts and look at the evidence and then give his order. So anyway, that's my thought on this whole lawsuit. And like I said, my prediction, if they do go into summary judgment, it could be that the plaintiffs will oppose converting the temporary or the preliminary injunction into a motion for summary judgment. And if that's the case, then they will, the trial will move forward as it was planned, right? So they've filed their motion for a preliminary injunction. The judge will rule on that motion for preliminary injunction, and then we'll move into the, standard process of preparing for trial and motions and, depositions and everything that goes along with the trial. So anyway, there you are, folks. My legal yet fully only my opinion on what I think this whole order from Monday means. And, like I said, I could be completely wrong, but that was just my gut when I heard it. So, like I said, take it for what it's worth, take it with a grain of salt. I hope this helped, maybe explain a little bit of what, sort of the asks were and why the lawsuit was filed, etc., and what it's asking for. And yeah, and I guess we'll see what happens on Monday. Like I said, very unlikely that we will have any kind of ruling in the case, even if they do move into summary judgment. But yeah, stay tuned. Thank you so much for watching. If you enjoyed the video, I would love it if you would give it a thumbs up. Let me know in the comments below What do you think about it? Do you think this is good news for the OFA? Do you think it's bad news for the OFA? I would love to hear your opinions in the comments. If you enjoy this kind of content and more focused on, my journey and also, different things about my life and how it may help you in your journey, then click the subscribe button and the notification bell so you know when I upload videos. If you would like to keep on watching some of my other videos, there'll be one in the corner over here for you to watch. And remember, kindness and hate spread the same. The choice is yours. I'll see you in the next video, guys. Take care. Bye-bye.